Hey, Ms. Rosenhoover, can you call courtroom 2, please?
Sure will do.
Thank you.
All right, good afternoon, everyone. We're going to go ahead and get started. This is the State Expedited Accusations calendar in the State Court of Fulton County, Georgia. I'm Judge Melanie Williams. And at this calendar today, we will address matters for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. As you can see, I'm conducting this hearing by video. I am not there in person with you. It's also being live streamed and recorded. That means any member of the public can log on and watch. When I ask if you understand your rights, that is what I am referring to. Those who receive a signature bond will be reset. Further notice, those who receive a surety or a cash bond will be reset to the state all-purpose calendar on let's see, August the 21st of 2025, whereby aspects of the case, including bond, contact, and other portions can be revisited. All right. Have all defense attorneys had the opportunity to interview their clients?
Good afternoon, Your Honor. Sarah Rosenhover with the Public Defender's Office. I know I've had an opportunity. I believe my colleague, Mr. Geddes, may be on the phone with someone who is bound over, and I don't know if Miss McLeod is ready.
All right. Any other defense attorneys who need to speak with their clients? All right. Okay, and other question, any interpreter cases today?
We don't have any interpreter cases.
Thank you. Any other announcements at the jail?
Yes, position number 5, she said ACDC. Yeah. Number 14, Dwayne Johnson, the medical reset.
You said, I'm sorry, 14 is a medical reset?
Yes.
Okay.
Number 18, Middleton, medical reset.
Okay.
Number 23, Simmons, wait his presence.
Yes.
And that's all the announcement I have at this time.
Thank you.
Doing position number 7, Mr. Cofer.
Yes.
All right, Mr. Coper, your case is 25 CR 00 4600B. You're charged with theft by shoplifting and criminal trespass. Do you understand your rights today?
Oh, if I take it. Let's go.
I'm sorry, do you understand your rights?
That's not.
All right.
71. He on probation, Fulton County for shoplifting. Got several open cases, trespass, shoplifting. He got quite a bit of shoplifting convictions. That's it.
Okay. Any theft by taking convictions?
Yeah, I don't know. Hold on. Let me see.
Working.
Yeah, 2017.
Okay, thank you. That's what I need to know. Ms. Falk, when you're ready.
Yes, Your Honor. Just to let the court know, we actually changed the theft by taking to a theft by shoplifting. This actually occurred when the defendant entered the Chevron at 507 Joseph E. Lowry Boulevard, grabbed 2 cases of Bud Light beer, and then walked out without paying for the items. The defendant was then arrested, and he had been previously issued criminal trespass warnings from that location several times and had violated those criminal trespass warnings by coming back into the store. The state did recommend this for a transfer. However, being it is a Saturday, we have not received a response yet from the DA's office, but we have transferred previous cases of Mr. Kofers to the DA's office because he is a theft by shoplifting recidivist several times over, as well as a repeat offender. The defendant also does not have, I believe, would not be, we would have a difficult time locating him. He is residentially challenged. And again, because of his lengthy history, I believe we heard over 60 cycles, we are asking for a $1,000 surety bond on each count, the criminal trespass as well as the theft by shoplifting. No further contact with the store owner, who is Mr. Gurmeet Tuteja, Gurmeet Tuteja, and stay away from the Chevron gas station at 507 Joseph E. Lowry Boulevard. No alcohol, drugs, or weapons. That's all for the state.
All right, who represents this defendant?
Nick Geddes of the Public Defender's Office, Your Honor.
Thank you, Mr. Geddes. Please proceed.
Thank you. So my client is a lifelong resident of Georgia. He has expressed to me that he has had some difficulties with housing in the past, but he does currently have an address that he's been able to stay at off and on. He does have several family members that live in Georgia. He has a GED and some experience with a technical college. Your Honor, my understanding is that he does not have long-term stable work. And so any kind of monetary bond that would be instituted would make it difficult for him to leave custody. We're just asking that the court give him the lowest possible bond given the circumstances.
All right, defendant's going to receive a $1,500 surety bond broken down 1,000, count 1, 500, count 2. He's to have no contact with the alleged victim. Stay away from that location, have no alcohol, drugs, weapons, and he's going to the all-purpose calendar on the 21st. Is there anything additional?
Nothing from the state.
All right, hearing none. Best of luck to you, Mr. Kofer. That concludes your case for today. What do we have next?
Number 26, Wilder.
All right, Mr. Wilder, your case is 25 CR 004606J. You're charged with criminal trespass and obstruction. You understand your rights this afternoon? I'm gonna assume that's a yes. Mr. Howard?
17, a resident of Inkster, Michigan. Yeah. You got an open case out of Michigan for assault, burglary, and a traffic offense. Another open case for assault, open case in South Fulton for trespass, on probation for criminal trespass in another county, 2024 trespass, 2023 assault, 2016 domestic violence conviction, and a 2013 malicious destruction of personal property conviction.
All right, thank you. Ms. Falk?
Yes, Your Honor. And after we address this, if the defendant Jamarcus Franklin is in court, the facts on the case are the same. So in this case, the defendant was at the Super 8 Motel, which is located at, 4979 Old National Highway. The defendant had been at that location and was observed breaking into hotel rooms more than once. When the police attempted to stop him, he did run away from the police. This is a bind-over case from College Park, and the bond that was set on this when it was bound over was $275 per count. We are asking for $500 per count for a total of a $1,000 surety bond. We are also asking for a stay away from the Super 8 Motel located at 4979 Old National Highway, and no alcohol, drugs, or weapons. That's all for the state.
Okay, thank you. Ms. McLeod, is this your case? You're muted.
Good afternoon, Your Honor. Is
Good
this Mr.
afternoon.
Wilder?
Mr. Wilder, David Wilder, this is your
Yes.
case?
Mr. Wilder is my client, Your Honor.
All right, please proceed.
Yes, Your Honor. My client tells me that he's currently homeless. He's having a hard time because he's not working right now. He's trying to find employment and hopes that he will find some kind of employment soon. So I'm asking the court to consider, given that this is a nonviolent offense, I signature bond for my client. If not, we'll be okay with the bond, which the state is suggesting, if the court is disinclined to give my client a signature bond, because he tells me he doesn't really have anyone to bond him out.
All right. Defendant's going to receive $1,000 surety bond, 500 on each count. He's to stay away from that Super 8 motel on Old National Highway, have no alcohol, drugs, or weapons, and he is also going to our all-purpose calendar on the 21st, whereby aspects of his case can be revisited. Best of luck to you, Mr. Wilder. That concludes your case for today. Can we take Mr. Franklin now?
Yes, ma'am, he's on the way up.
Thank you. All right, Mr. Franklin, your case is 25 CR 004604C. You are charged with obstruction and criminal trespass. Do you understand your rights?
No.
Is that a yes? I'm assuming it's a yes. All right, Mr. Howard.
5. You got an open case in Superior Court for shoplifting, obstruction, interference with government property. 24 PI 006215. Open drug case out of Fayette County. 2024 failure to appear. 2023 trespass, obstruction. That's it.
All right, thank you. Ms. Falk, I have the
Yes, sure.
facts.
Yes, Your Honor, and the bond request is the same, $1,000 surety bond broken down 500 per count. Stay away from the Super 8 motel at 4979 Old National Highway, no alcohol, drugs, or weapons.
All right, thank you. Mr. Geddes?
Yes, thank you, Your Honor. My client's 24 years old. He was born in Georgia. He's lived here for the majority of his life. He has a 4-year-old son, as well as several family members who live in Georgia. My understanding is that he currently works as a delivery driver for Amazon. He's currently staying at his with his dad, so he does have stable housing. He's a high school graduate. If he's eligible for a UJR, we are asking the court to consider it, but if not, just the lowest possible bond given the circumstances.
Defendant will also receive $1,000 surety bond, 500 on each count. He's to stay away from that Super 8 motel, have no alcohol, drugs, weapons, and he will be reset as well to all purpose on the 21st. Is there anything additional from state or defense?
None, Your Honor.
All right.
Nothing, Your Honor.
Best of luck to you, Mr. Franklin. That concludes your case for today.
Look, y'all know I ain't doing that.
Number 24.
All right. This is Mr. Strigel.
Yes, ma'am.
All right. Your case is 25 CR 004594F. You're charged with simple battery family violence and battery family violence with the offense date of August the 8th. You understand your rights today?
Yeah.
What number is this?
24. Mr. Howard.
Hold on. Okay. Alrighty. Let's see. Oh, this is second arrest. He got a suspended license out of Hateville, and he's wanted out of Hateville according to the booking. That's it. Well, it's suspended license and fleeing officer.
Okay. Thank you. Ms. Falk?
Yes, Your Honor. The co-defendant in this case is Asia Young, who is the victim in the current case. She is currently being held in the DA's office with a felony aggravated assault, possession of a firearm during commission of a felony, with this defendant as the victim. This incident happened on August 8th, 2025 at 6760 Buffington Road in Union City. The two of them were in a dispute. They live together and are parents of a 4-month-old child. During the dispute, they wished to sleep in separate rooms. Ms. Young stated that the defendant went into her room and took a fan she was using and ended up striking her in the legs and the thigh area. Officers did see red scratches on her legs and thighs from the fan being used as what they described as being used as a weapon. Given the defendant has very little history and Ms. Young is currently being held for pistol whipping Mr. Stargell, we are agreeable to an SOB through pretrial services. No further contact with Asia Young. We are okay with the defendant, Mr. Stargell, returning to the residence, and no alcohol, drugs, or weapons.
Okay, thank you. Ms. McLeod, this is your case?
It's my case, Your Honor, and we are fine with the signature bond, and of course, that is his home, so we are okay with him being able to go back there. We're also okay with the no further contact.
All right. Defendant is going to receive a $3,000 signature bond at level 1 through pretrial services, 1,000 on the simple, 2,000 on the battery. He is to have no contact with Ms. Young and have no alcohol, drugs, weapons. He will be reset for the notice as he received an SOB. Is there anything additional?
Nothing further, Your Honor.
All right. Best of luck to you, sir. That concludes your case just for today.
Thank you.
All right, who do we have next?
Number 11,
Your Honor, other than, I believe you said level 1, other than the no further contact, no alcohol, drugs, or weapons, there were no other conditions, correct?
Correct. I'm not going to require that one-day class.
Oh, I didn't request it. I just wanted to make sure. I'm trying to take notes as well.
I understand.
Thank you.
You're a one-woman show today, Ms. Paul. All right. Is this Mr. Higgins?
Yeah.
All right, Mr. Higgins, your case is 25 CR 004601C. In this case, you are charged with 2 counts of simple battery family violence and 1 count of battery family violence. Do you understand your rights today? Is that a yes?
Yes.
All right, thank you. I have this as his first arrest, so we can go right to you, Ms. Falk.
Yes, Your Honor. This happened August 8th, 2025 at 31 Cleveland Avenue in Atlanta. Miss Shakaya Higgins stated that she was in an argument with her brother, Marquavius Higgins, over the cell phone charger, and they began arguing. The defendant then opened her door, began punching her in the face. She stated that during the altercation, he also choked her by wrapping his arm around her neck in a chokehold. She stated she did not feel like she would lose consciousness, and at that point, she began scratching at him. When he placed her in the chokehold, he let her go and then left the room. They do currently live together, which is the reason for the family violence. This is his first offense. We are agreeable to an SOB through pretrial services. No further contact with Shakaya Higgins. Stay away from 31 Cleveland Avenue in Atlanta. No alcohol, drugs, or weapons. We are going to ask for anger awareness in this case due to the fact that there was a strangulation involved. And we are going to ask for no firearms as a special provision as well. We would like to sound for Ms. Shakaya Higgins at this time. That's all for the state.
All right, is Ms. Higgins present and wishes to make a brief statement? I don't see anyone on the screen. I'm gonna sound one more time. Ms. Higgins. Okay. Ms. McLeod?
His mom is present.
It's on,
Okay.
Your Honor. I was
I
about to
don't
point
know
that
about.
out. But before Mom speaks, I would just like to say, Your Honor, that my client is only 18 years old. He has absolutely no record. I was able to speak with Mom, and Mom definitively wants him back home. He is her younger child. The other one, the alleged victim, also lives there. My client's mom is not prepared to put her son on the street because of her daughter. She says her son is not a problem child at all. She was at work when this incident happened, and she strongly believes that her son was not necessarily aggressive in this, Your Honor, and she wants him protected. She wants him back home. I have spoken to her, and she's on the Zoom.
Defendant is going to receive a $3,000 signature bond at level 2 through pretrial services. He's going to take a 2-day anger awareness course. He's to have no further violent contact with the alleged victim in this case. Is there anything additional from
Your Honor, no, Your Honor, I just wanted to make sure
I'm sorry, you wanted to make sure of what, Ms. McLeod?
that he was not going to be on the street. He's only 18 years old.
I didn't.
No,
Did
you
you?
did not, Your Honor.
I
That's
did
why I
not.
was just saying
Okay.
that. That's why I had to put
Okay.
that out there that I had spoken with
He
Mom.
can go back home, and he's also going to do 10 hours of community service.
Yeah, that's fine. I mean, he just
No,
graduated.
ma'am. No, ma'am. No, ma'am. You can speak to Ms. McLeod. She'll advocate for you at a later time.
Okay, all right,
I don't
that's
mean to
fine.
cut you off. It's a long calendar today. All right. All right. Best of luck to you, Mr. Higgins. That concludes your case at this time.
You said 4,000?
It's 3 because I
3.
thought it was 4 charges. It's 1,000 each count.
All right.
Thank you, Your Honor.
All right, Attorney
One.
Smith is on the line. Can we take his client, Mr. Tamiko Cameron?
And I'm sorry, Your Honor, they had me over in felony Zoom court when they sent me the link. I didn't realize it was this link. I'm sorry about
I'm
that.
sorry, I don't see anybody with that name on here.
Well,
What's
they
the
told me
name?
to appear on this calendar. We were in court a few hours ago, and they told me to come back on this calendar. Well,
What's the name?
They addressed us on that calendar, and they told me I had
Okay, hold on. What's your client's name? Let's get that.
Tamiko Cameron.
I NOD'd that case, Your Honor.
Okay, that case has been dismissed. All right.
Okay,
Thank you, Mrs. Smith. Take care. Have a good afternoon.
And Your Honor, before I leave, was there a formal accusation on this? Or it was just an outright dismissal of the charges.
It was an outright dismissal of the charges, sir.
All right. Would you mind giving me that case number, please? Just
Can
for
we need to keep moving, Mrs. Smith. I don't mean to be rude. Can you chat, Miss Falk, perhaps? All right.
Number one,
Miss Strong, can you give him that information for me? I don't mean to be rude, Mrs. Smith. I know you are doing your best to advocate for your client, but we need to keep moving.
I
All
understand,
right.
Your Honor.
All right, thank you. Who's in the chair?
number one,
All right, this is Kendrick Alberty. Your case is 25 CR 004561C. You're charged with 2 counts of simple assault, 1 count of disorderly, and 1 count of criminal trespass. Do you understand your rights today?
Yes, Your Honor.
All right, thank you, Mr. Howard.
14. You got to open trespass. That's a pretrial bond. 2021 FTA. 2020 trespass conviction. 2011 simple assault, 2 counts. Damage to property, theft by taking, trespass conviction. That's it.
2011 simple assault. Okay. All right, thank you, Ms. Falk.
Yes, Your Honor. This incident happened on August 7th, 2024 at the laundromat at 2100 Cheshire Bridge Road in Atlanta. Officers actually located the defendant at the Waffle House at 2264 Cheshire Bridge Road, where he was causing a disturbance. The employees at the Waffle House were concerned, so they called the police. That led them to talk to Terry and Chris Stark, the owners of the laundromat at 2100 Cheshire Bridge Road, where the defendant had come from. They stated the defendant had entered that location, had asked about an employment opportunity. They had to explain to him that they did not have one available at the time. They had just filled a position. The defendant became very upset, banging on the washing machines, began throwing magazines at Miss Terry Stark, and then pulled a knife on Mr. Chris Stark. Mr. Stark was able to push the defendant out of the business using a taser that unfortunately wasn't working, but he was able to hit him with it and get him out of the store. And that's when the defendant went over to the Waffle House. As Your Honor heard, the defendant has 13 cycles. He currently has the open criminal trespass, which is 25 CR 004132C. He has a 5,000 signature bond through pretrial services from Judge Morrow, with a stay away from the Waffle House at 2264 Cheshire Bridge Road and a social worker visit. That was the same Waffle House he was found at after this incident. He also has an FTA from 2021 out of Cobb County, and a 2012 criminal damage to property in the second degree conviction. For those reasons, we are asking for a $4,000 surety bond, $1,000 per count. Stay away from the laundromat at 2100 Cheshire Bridge Road in Atlanta. No further contact with Terry and Chris Stark. We're also requesting an MHET on this due to the circumstances and no alcohol, drugs, or weapons. We did speak with Mr. Terry and, well, the Starks, and they stated that he has never seen the defendant prior to this incident. He does fear retaliation, does fear the defendant will return, wants no contact with him, and wants him to stay away from the property. We would like to sound for Mr. Chris Stark if he is here on the Zoom. That's all for the state.
Okay. Are either of the Starks present and wish to make a very brief statement?
Present, but no statement necessary. Thank
All
you.
right, thank you. All right, thank you. I appreciate you coming to court. Mr. Geddes?
Yes, thank you, Your Honor. My client is 39 years old. He is a lifelong resident of Georgia. He's expressed to me he has numerous family members, parents, siblings. He has a nephew who he treats as a son, who's roughly 11 years old. My understanding is that up until recently, he was working as a chef, but did unfortunately lose his job due to some cutbacks there. He's expressed to me he is a high school graduate and does have some college schooling. Your Honor, we would just ask you to give the lowest possible bond considering the circumstances. If a bond is placed that my client's not able to make, we would ask that he be allowed a social worker visit.
All right, thank you. Let's see. Defendant is gonna receive $1,000 surety bond, $250 on each count. He's to stay away from that Waffle House, have no contact with either of the alleged victims whatsoever. I'm actually gonna put in that he needs to stay 1,000 yards from that Waffle House. I am gonna request that a social worker visit him, and he's to have no alcohol, drugs, or weapons. He's going to state all-purpose calendar on the 21st. Is there anything additional?
Yes, Your Honor, we'd ask for the stay away from the laundromat at 2100 Cheshire Bridge Road,
All right, same
since that was the
away
initial
where it
location.
originally was. Right, all right. You can stay away from there as well, but the same 1,000-yard requirement. All right, best of luck to you, sir. That concludes your case.
Number 13. Oh, see, you gonna come to.
All right, this is Umar Issa. Your case is 25 CR 004585B. Your case, let's see, you're charged with possessing an altered document. Do you understand your rights today?
No.
All right, Mr. Howard.
It's his first. He lives in Nigeria, and that's what the booking sheet says. Lives in Nigeria.
All right.
Nothing further.
All right. Thank you, Ms. Falk.
Yes, Your Honor. Just a moment. This happened on August 7th of 2025. It appears that the defendant was pulled over inside of a stolen vehicle, or a vehicle that was reported stolen. Mr. Ibrahim Jawando had stated he had been tracking his stolen vehicle on his phone and saw the vehicle parked on the street with its hazards on, saw two males leaving the vehicle on the street and going inside of an apartment. He had made a police report earlier that day reporting the vehicle stolen. The officers then saw there was a wallet inside the vehicle, which Mr. Jawando stated was not his. While they were investigating the scene, two individuals came out. One, Mr. Mohammed Abadram, and the defendant. The defendant was advised that his wallet was a wallet inside the car. Officers saw that the defendant had multiple identifications of himself, credit cards, and multiple pictures inside the wallet when he was later detained. It was also showed that the defendant was carrying a fake South Carolina license, and he advised he was not a citizen. He was only here to visit, and he has been here for 10 days. The state has some serious concerns, especially considering there were multiple identifications located inside of that wallet, not just the fake South Carolina license, as well as multiple pictures inside of the wallet, especially considering the defendant himself stated he had only been in the States for 10 days. Had only been visiting Georgia for 10 days. So we are asking, especially because I have concerns about where his residency is and whether he has ties to this community or not. We are asking for a $5,000 surety bond and no further contact with Mr. Ibrahim Jawando, IBRAHEEM JAWANDO, no alcohol, drugs, or weapons, and reset it to SAP. That's all for the state.
All right, thank you, Mr. Geddes.
Yes,
Your
thank
Honor, if I could speak in, I'm his brother.
No, go ahead, Mr. Geddes.
Yes, thank you. So my client is 40 years old. My understanding is that it is correct that he lives out of Nigeria and he is here visiting friends living in Georgia. He's expressed that I believe his brother also lives in Georgia, and that was part of why he was visiting here. He is employed in Nigeria as a construction worker. Your Honor, considering that he has no prior arrests, we are asking the court to consider the lowest possible bond. As his brother is here on the line, and as I said, he lives here in Georgia and was visiting him, I've explained to him that this is an ongoing process and he will need to come back and continue visiting, and he seemed to understand that.
All right. Defendant is going to receive a $50 cash bond. He's to have no contact with Mr. Jawando, have no alcohol, drugs, or weapons. Because I'm giving him the cash bond, he'll be reset to the all-purpose calendar. Is there anything additional from the state or from the defense?
Your Honor, we would just like to object or at least ask that he have to surrender his passport. Once he pays his bond, we are never going to see this guy again, in my state's opinion.
All right, duly noted, Ms. Falk, but denied. Best of luck to you, sir. That concludes your case. Is there anything additional?
Nothing from the
Nothing
state.
from the state.
All right. Who do we have next?
Position number 19, Mr. Moore.
Mr. Moore, your case is 25 CR 004590E. You are charged with interference with custody. Do you understand your rights today?
Yes, ma'am.
All right. Mr. Howard.
15 on probation, possession of marijuana with intent. On probation for hijacking motor vehicle, ag assault, battery. 2025 fade to appear. He got some battery DV charges, convictions from the past. And I know his booking says CPO returned to Hall County. That's it.
Okay. Miss Falk.
Yes, Your Honor. Pardon me, Mr. Howard. What does the CPO mean?
Court production order.
Ah, okay. Thank you. I'm just not as familiar with that. I appreciate that. Okay, so Your Honor, the 22 SC 183968 case where the defendant, the hijacking a motor vehicle, aggravated assault, family violence battery, that was pled down from a hijacking to a criminal trespass, and the family violence batteries were kept and made consecutive. The aggravated assault was reduced to a family violence battery, and that involved Miss Justice Williams, and the defendant is still on probation. He was just sentenced June 23rd of 2025 on that case. In this case, Your Honor, officers spoke with Miss Demi Tomlin on July 6, 2025. She stated that she had a court order from June 3rd, 2025, where Judge Benton had granted her sole custody of her son, ZT, who was at the time of this incident 8 years of age. The defendant refused to comply with the order, refused to grant access to her son, and had been hiding her son from her since October of 2024. She also stated that he was leaving her child with people she did not know. She finally, after getting that court order on June 3rd, got the defendant to agree to meet her at his barbershop so she could pick up her son. She waited for 2 hours. The defendant never showed up. And at that point, she called the police and made a police report regarding the fact that her son was essentially not being returned to her. I will say that my real concern here, and when they finally did speak to the defendant on July 4th of 2025, he was in the Hall County Jail, and he advised the officers that ZT was in Philadelphia, Pennsylvania with his grandmother. And so at that point, he was told that he needs to make arrangements to return his son back to the state of Georgia and back to the lawful custody of the mother, Miss Tomlin. The state is really concerned in regards to this case, Your Honor. This is essentially, this man took his son, took him away from his mother out of the state for over 8 months. And this mom had to go get a court order. And even after getting a court order, he still refused to comply. I mean, essentially, he's basically kidnapping his own son away from his lawful guardian. For that reason, we are asking for a $10,000 surety bond. We are asking for no further contact with ZT, no further contact with Miss Demi Tomlin, and stay away from them absolutely unless he has a court order saying otherwise. No alcohol, drugs, or weapons. And again, Your Honor, I do want to point out with his history of family violence, which he is still under sentence for currently, and his other history, we do have concerns about a risk of reoffense here and him possibly taking the child out of state again. That's all for the state. We would like to sound for Miss Demi Tomlin.
Okay. And the allegation, Ms. Falk, is that he has no custodial rights at all?
That is correct, Your Honor. Judge Alice Benton granted Demi Tomlin, I think, sole legal custody of her son. It says below she was granted sole custody of her son,
It's
ZT.
legal and physical.
No, don't start talking yet, Ms. Tomlin. Hold on. I'm sorry,
So
Ms. Falk.
it sounds like it was both both sole legal and physical custody of her son.
Okay. Hold on, give me a second. All right, Ms. Tomlin, I'm going to let you make a brief statement. Please raise your right hand, but I'm going to give you some instructions. Whether you disagree with what Ms. Falk has to say today or how she presented the case, that's not what I'm most concerned with. I'm most concerned with today concerns for your safety and whether you wish to have any contact with the defendant. This is a bond hearing and there will be other proceedings whereby the facts will be fleshed out, okay? Do you swear or
Yes, ma'am.
affirm the testimony you give today be the truth to the best of your knowledge?
Yes.
All right, what would you like to tell me today?
I just want it to be known to the court that this custody battle started in 2021. We were in Judge Farmer's chambers, and unfortunately, the case was ignored. We filed over 10 contempt motions. He refused the past 4 years to abide by any court order. He has threatened me. Oh, if you try to go to our son's school, you're going to go to jail. I'm the one who's in control, even though we had 50-50 with the right of refusal before I was granted sole custody. He walked into court 20 minutes late, as our order that's already in Fulton County Superior Court states. He thinks he's above the law because, as you heard, all of his charges always get minimized. He's done this to other women, not just me. And he also still now, the woman who actually brought my son to the police station on this last occurrence, I actually had to get a TPO on her because she put a tracker in our son's bag and has been stalking me, sending mail to my house. So this is ongoing. He even from jail, he lied to the officers, told them my son was in Philly, and even still from jail has somebody harassing me. And it's not okay. He does not care that he owes me child support, but he went and he retained an attorney for his last case in Hall County the other day. It's just he doesn't care that what he's doing, the toll it takes on my mental health. I have to be a parent not only to our child, but a 13-year-old and a 3-year-old as well. I have 3 children, not just ours. And he doesn't understand what all of his actions are causing in my life, which is very hard to be a parent without all these issues. All of this is unnecessary. I shouldn't even be having to do this. I went to court rightfully, and he didn't abide by that. And he won't abide by y'all order. Who am I? I'm nobody to him, clearly.
All right, so I'm assuming you don't want him to contact you at all.
Absolutely not.
Okay.
No, never.
All right. I appreciate you coming to court and making that statement, Ms. Tomlin. Thank you.
And
Ms. Rosen.
Your Honor, just really briefly, I do apologize. The warrant at the very, very bottom does say that the child was not out of state. He did lie to the officers, and the child was actually in town with another individual.
All right. Thank you. Ms. Rosenhuber.
Thank you, Judge. Mr. Moore is 33 years old. He has resided here in Georgia since he was 12 years old. He did earn his bachelor's degree from the University of Kansas, and he also obtained his associate's degree. As the court heard, he does have a barber shop that he owns and operates here in Buckhead. And Judge, he is going to be in Hall County custody, it's my understanding, until at least November. He doesn't have the resources with which to post a bond. Judge, we would ask for a reasonable bond given the circumstances. Thank you.
All right. Defendant is going to receive a $3,000 surety bond. He's to have no contact with the alleged victim or the minor child unless he has the parenting documentation that indicates that he can do so. He's to have no alcohol, drugs, or weapons, and he will be reset to all purpose on the 21st. Is there anything additional?
Just to stay away from her residence or workplace.
All right, and we can abide by that. Stay away. All right.
Thank you, Your Honor.
All right. Best of luck to all parties concerned in this case. That concludes your case for today, Mr. Moore. Who do we have next?
ACDC, go.
Has ACDC heard their rights?
Good afternoon, Judge. No, she has not.
All right. Good afternoon. I'm sorry, what is the young lady's name?
Position number 5, Ms. Carrasco.
All right, Ms. Carrasco, your case is 25 CR 004598G. You're charged with battery of family violence and 2 counts of simple battery of family violence. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today, and as you can see, I am conducting this hearing by video. That means any member of the public can log on and watch. Do you understand your rights and how I'm conducting the hearing today? Ms. Carrasco, you understand your rights? All right, thank you. Mr. Howard. Oh, this is first, so we'll go to Ms. Fault.
Yes, Your Honor. This case actually had a co-defendant who appeared in court yesterday. We are going to be asking for the same bond, which it was an SOB through pretrial. In this case, the officers went to 3200 Lake Place in East Point. The 2 individuals had been a physical altercation after an argument about infidelity. The defendant in this case struck Mr. Pharaoh Rivers, leaving visible marks on his right hand and his left arm. They were both charged with family violence battery. We are asking for the same bond that Mr. Rivers received, which is going to be a 3,000 SOB through pretrial services, 24 weeks of family violence intervention program, and no further violent contact with Pharaoh Rivers. Miss Judge Law, that I will state the defendant, Mr. Rivers, also did not have any prior family violence, but Judge Law, given the fact that 2 had only been together for 3 months, I believe, felt that both would benefit from family violence intervention program and stated as such on record. So we are just asking Your Honor to follow the court order that was provided to Mr. Rivers to Ms. Carrasco. That's all for the state. Oh, and we did, just briefly, we did speak to Mr. Rivers. He does want contact and wants the victim to come home, which again, he received no further violent contact, which is what we're asking for. And so we would like to sound for Mr. Rivers, again, advising him that he has the right to remain silent since he is a co-defendant in this case.
All right, Mr. Rivers, if you're present, would you like to make a very brief statement? I don't recommend that you do, honestly, but if you're here, would you like to make a statement?
Yeah, I'm here.
You need to turn on your camera, raise your right hand.
Yeah.
I really don't think you should do this, but
Yeah,
do you swear?
I am advising you not to say anything.
Yeah, I don't think you should make a statement today, Mr. Rivers,
And
okay?
Ms. McLeod did represent Mr. Rivers, Your Honor.
Okay, so I don't think you should. Okay, I think you should speak to Ms. McLeod, okay? All right. Mr. Geddes.
Yes, thank you, Your Honor. My client is 21 years old. She is currently a full-time student at Gwinnett Tech. My understanding is that she is a freshman there. She has spoken to me, and she also wishes to be able to have further contact with the co-defendant. My understanding is that the state has no issue with that. We obviously have no issue with the SOB bond. I think the only concern that we would have would be the 24 weeks of the Family Violence Intervention Program. She's a student. Her income is minimal at best, and this is her first arrest. I would just ask that she not be required to take those classes.
All right. Defendant is going to receive a $3,000 signature bond through pretrial services at level 1, 1,000 on each count. She's to have no further violent contact with Mr. Rivers, and she's going to take a 2-day anger awareness course. Have no alcohol, no drugs, no weapons. Is there anything additional?
Nothing from the state.
All right. Best of luck to all parties concerned. Who do we have next?
Number 2, Demario Brown.
Come on, bro.
Mr. Brown, your case is 25 CR 004595F. You're charged with simple assault. You understand your rights?
Yes, ma'am.
All right. Mr. Howard.
16. Got an open terrorist threats. 25 CR 001055F. Open false statement and tampering with evidence. 25 PI 000121. Open theft by receiving DUI. Open container. It's 25 SC 000062. Has a fade to appear. Open fleeing an officer, driving without a valid license, reckless driving. DUI 24 CR 00002F. 2024 fade to appear. 2017 fade to appear. And a battery charge. That's it.
All right, thank you. Ms. Falk?
Yes, Your Honor. You actually, on the terroristic threats, gave him a $1,000 surety bond on that case, as well as, just wanted to go back and look at that case really quickly, as well as let me see. Back on March 1st of 2025, you gave him a $1,000 good bond, no further contact with John O and Naomi Foster, and stay away from 2655 Donnelly Hollowell Parkway in Atlanta, Georgia. No alcohol, drugs, or weapons. In this case, Your Honor, the defendant was at the location of 3143 Hickman Drive Northwest on August 8th. He was in a verbal argument with the victim, Miss Casey Harris. During that argument, he began accusing her of seeing someone else. The argument turned physical. He began pulling out knives, stating, "I am going to hurt somebody," and repeatedly sticking knives into objects around the house. Due to that, she ended up calling her aunt to assist her to her mother's house. And once at that location, they left heading toward Miss Harris's mother's home at Hickman Drive. At that location, she stated that when she was leaving for work, accompanied by her aunt, she was again confronted by the defendant. He again accused her of infidelity. And at this second dispute, he was holding his shirt with a machete underneath. The machete was also observed by the aunt. After that second argument, he tried to block her in. She was able to get into her vehicle, and the defendant began following her. The officer then pulled the vehicle over, drew his weapon because of the information he was receiving regarding machete, and the defendant was then placed under arrest. This defendant has a lot of open cases and some FTAs. So we are concerned he is both a likelihood of reoffense as well as a danger to others and to the community in general. He has that 24 CR open case as well as the 25 CR open case. On the 24 CR open case, Your Honor, may not have been Your Honor, he received a bond on that case, which was then forfeited on November 18th of 2024, and then rebonded on that case. The initial order for release was in January of 2024 and was an SOB through pretrial from Judge Morrow. So we are asking on this case, due to the severity of the offense, a $5,000 surety bond, no further contact with the victim, Miss Casey Harris. We're also asking to stay away from 3143 Hickman Drive Northwest, as well as their residence at 2050 Fleet Street Southwest. No alcohol, drugs, or weapons. We would at this time like to sound for Miss Casey Harris, and she does state, we did have an opportunity to speak with her, and she does state she wants a no further contact and a stay away until he is able to do better for himself. We would also request a social worker visit, and that was by Mrs. Harris's request due to her concerns for MH issues. That's all for the state.
All right, Ms. Harris, if you wish to make a brief statement, please unmute, turn your camera on, raise your right hand. Okay. Mr. Geddes?
Yes, thank you, Your Honor. My client is 32 years old and has been a lifelong resident of Georgia. We have already discussed the possibility of a stay away being placed, and he has told me he does have another address he would be able to stay at. My understanding is that he has numerous family members in Georgia, including his mother, aunts, children that he has here. My understanding is that he is gainfully employed through a temp service based out of Georgia. Your Honor, we're just asking you to consider the lowest possible bond given the circumstances.
All right. Defendant is going to receive a $2,000 surety bond. He's to have no contact with Ms. Harris, stay away from the Fleet Street address, as well as the Hickman Drive address. He is to have no alcohol, drugs, or weapons, and he's going to all purpose on the 21st. Is there anything additional?
Is Your Honor inclined to order that social worker visit?
Oh, yes, if the social worker could visit him while he's there as well. All right.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Mr. Falk, will you tell Ms. Strong those address? I think I had 3143 Hickman and 2050 Fleet Street.
It
Okay,
is 2150 Fleet Street and 3143 Hickman Drive Northwest.
okay, thank you.
Almost, but not quite. All right, best of luck to you, Mr. Brown.
I'm sorry, Your Honor. It's 2050 Fleet Street.
Right. We did have 2050 Fleet Street, ma'am. We were also saying for him to stay away from 3143 Hickman Drive Northwest, which was your aunt's or your mother's home.
All right. All right, best of luck to all parties concerned. Who do we have next?
Number 6, Carter. Have a seat for a moment. Somebody gonna come take a picture.
All right, Mr. Carter, your case is 25 CR 004599B. You are charged with theft by taking. You understand your rights? Is that a yes? All right. I have this is first, Ms. Falk.
Yes, Your Honor. This incident happened on, let's see, July 25th of 2025. The defendant was an employee at the, let me see, let me just catch up here. The defendant was working at Pruitt Health, and he was an employee from that location. He stole over $500 worth of food from the kitchen, 2 boxes of chicken, some rib tips, and a pack of spare ribs. We do ask for a signature bond through pretrial services. No, stay away from that location, which is Pruitt Health at 2645 Whiting Street Northwest in Atlanta, if he is no longer employed there. No alcohol, drugs, or weapons, and that's all for the state.
All right. Mr. Geddes, this is your client.
It is, Your Honor.
Do you object to the signature bond through the jail with that stay away?
We do not.
All right, defendant is going to receive a $5,000 SOB through the jail. He's to stay away from that location if he's not employed there, have no alcohol, no drugs, no weapons, and he will be reset for the notice. Is there anything additional?
Nothing from defense.
Nothing from the state.
All right, best of luck, sir. That concludes your case.
Position number 9, Mr. Gasson.
All right, Mr. Gadsing, your case is 25 CR 004583G. You are charged with criminal trespass and possession and use of drug-related objects. You understand your rights today?
Yes, ma'am.
All right, thank you, Mr. Howard.
32. He has a forgery, no law in his history, possession of drug-related objects, theft, trespass, conviction, entering auto.
All right, thank you, Ms. Were you finished, Mr. Howard?
Yes.
Thank you. All right, Ms. Falk.
Yes, Your Honor. Just give me a moment to catch up. All right. So this incident happened on August 8th of 2025 at the SP parking lot at 123 Marietta Street Northwest. Officers were flagged down by the property manager, who stated the defendant, who was a known trespasser who'd been at that location on July 25th of 2025, was back at the location. The defendant was then arrested and a used crack pipe was found in his pocket. We would say that given his lengthy history, we would ask for a $1,000 surety bond, $500 on the criminal trespass, $500 on the possession and use of drug-related objects. We're in the alternative. I know that the defense usually prefers a $1,000 surety bond, but if they would prefer a lower bond, 500 surety on the criminal trespass and 500 signature bond through the jail on the possession and use of drug-related objects. We do also ask for no alcohol, drugs, or weapons in the social worker visit for mainly housing. I'm just concerned about the defendant's current residential status. That's all for the state.
Thank you.
Oh, and stay away from that location.
All right. Thank you, Ms. Falk. Mr. Geddes.
Thank you, Your Honor. My client is 65 years old. He's a lifelong resident of Georgia. He has expressed to me that he has some form of housing based out of Union City, but it's not clear to me whether or not that's consistent or long-term. He did also express to me that from 1979 to 1985, he served with the United States Marine Corps. My understanding is that he is not currently working. He was able to graduate high school. We would just ask the court to consider the lowest possible bond given his circumstances.
All right, defendant's going to receive a $20 cash bond, $10 on each count. He's to stay away from that gas station, have no alcohol, no drugs, no weapons, and he'll be reset to all purpose on the 21st. Is there anything additional?
I'm sorry, I don't see the address for the gas station.
It's a parking lot, and it's the address is going to be make sure I'm not wrong about this, 123 Marietta Street Northwest in Atlanta, and the parking lot is SP Parking.
Thank you.
All right, who do we have next?
And Your Honor, just in case he's not able to get out, we would ask for the social worker visit.
Oh yeah, and the social worker, please allow the social worker to visit him as well.
Number 15.
All right, Mr. Kazinga, your case, I'm sorry if I'm saying it wrong. Your case is 25 CR 004586Y. You're charged with theft by taking. You understand your rights? All right, this is first, so we'll go to Ms. Falk.
Yes, Your Honor. The defendant in this case was an employee at the location, which is, which is going to be the Walmart at 5200 Windward Parkway. The defendant was scanning, basically pretending to scan various food and cleaning supplies. He was paying each time only for the items he actually scanned. At the time he was working on shift when he was doing this, the items were stolen from June 11th, 2025 to August 5th of 2025 in the amount of $213.04. The defendant did sign a voluntary statement admitting that he had done this at that Walmart. We are asking for a signature bond through pretrial services level 1, no further, stay away from the 5200 Windward Parkway Alpharetta Walmart, no alcohol, drugs, or weapons. That's all for the state.
All right, Mr. Geddes, you object to a signature bond through the jail?
We would
And
not.
stay away? All right, defendant will receive a $5,000 signature bond through the jail. He's to stay away from that location on Windward Parkway, have no alcohol, drugs, or weapons, and he'll be reset for the notice. Best of luck to you, sir. That concludes your case for today. Who do we have next?
Number 16.
Did you say a 5,000 through the jail, Your Honor?
I did.
Okay, thank you.
All right, sir, your case is 25 CR 004602A. And in this case, you're charged with battery, family violence, criminal trespass and damage, simple battery, family violence, 2 counts of that, and obstruction. Do you understand your rights today?
Yes, ma'am.
All right, Mr. Howard.
13. You got to open criminal damage to property out of Clayton County. On probation out of Gwinnett for ag stalking. 2024 parole violation. 2023 same thing. Got a 2019 ag stalking trespass, criminal damage to property, first offender, and a 2018 failure to appear.
Ms. Falk?
Yes, Your Honor. So this incident happened back on August 7th, so 2 days ago, at the 125 Somerset Lane in Sandy Springs. Officers spoke with Miss Helen Booker, who stated that the defendant had damaged her vehicle. She stated that the side of the front passenger door had been damaged by having the metal bent, and also that her car keys were gone. She estimated that the damage to the door was about $100. The car key damage was, the lost key fob was about $20. She also stated that she was in a relationship with the defendant. They were dating, but they don't currently live together. However, they had lived together in the past. She advised that they were having an argument. She stated that she was in the vehicle with him. They were getting off on Abernathy Road. They began having an argument. The defendant started to punch her while he was driving and then pulled the vehicle over and continued to beat her by punching her with his fists and then put his arm around her neck in a type of chokehold. And while doing that, she stated she grabbed her pistol and that she kept behind the passenger seat and struck him in the head with it. She stated that after striking him in the head, he did release her. And at that point, he stopped attacking her and she was able to get to 125 Somerset Lane, where a friend tried to de-escalate the situation and then took Miss Booker away from the scene. She did have scrapes and swellings to her cheeks. And we will say that when they went to talk to the defendant, he refused to talk, refused to identify himself, and was placed under arrest. We did have an opportunity to speak with Miss Booker on this case, and I will say her standpoint has changed drastically from when we initially spoke with her. She stated she was drunk during the incident, which does not appear to be the case per the warrant. And she also stated that she does not want to move forward. I will say that she was quite detailed with her statement to police, although she says she does not remember any of her statement, but she was detailed to the point of telling the officers how much each of the items cost that were damaged and that were missing. Given the defendant's history of aggravated stalking and given his history of FTAs, the most recent one, I believe, being 2018, we are going to ask for a $5,000 surety bond, $1,000 per count, no further contact with Helen Booker. We are also asking for a stay away from her residence or workplace. I understand it's been less than 48 hours at this point, so we are concerned about a lack of cooling off during this time. And we would also ask for no alcohol, drugs, or weapons in a family violence intervention program due to the prior history of ag stalkings. We would like to sound from Ms. Helen Booker at this time. That's all for the state.
All right. Is Ms. Booker present? Wants to make a statement?
Yes, I am.
Turn on your camera, raise your right hand. Do
Hold
it
on.
quick.
I'm trying to
quickly.
turn my camera on.
Do you swear or affirm the testimony you give today be the truth to the best of your knowledge?
Yes, I am.
You do? You mean? All right, put your hand down. What I'm most concerned with are concerns you have for your safety today, and whether you wish to have contact, the facts of the case, and if you wish to add, there will be other proceedings where you can do that. What would you like to tell me today, Ms. Booker?
That none of the incident that was verbalized to the police officer, I was drunk, I was intoxicated, and that's what we was having an argument over. So whatever I stated and whatever the DA is saying is not true at all. I respectfully request a thorough review and dismissal of the charges against Mr. German Lovenowics. I wish to be with him. We've been together and we briefly stayed together for maybe 2 to 3 weeks, but we don't live together. We don't have kids together. And I do not request that charges be filed, nor do I wish for the state of Georgia to pursue any legal actions against him.
Thank you. Ms. Rosenhoover, please proceed.
Yes, Your Honor. My client is 38 years old. He has resided here in Georgia for the past 20 years. He does have family here. He stays at the address on file in Duluth with his parents. He does have 2 daughters, and he made it to the 11th grade. While he is currently unemployed and cannot post a high bond at all, he was doing construction work previously. Given the alleged victim's stance on this case, Judge, we would request a signature bond through pretrial.
Your Honor, if I may ask Ms. Booker one question.
Very quickly.
Ms. Booker, were you the subject of either one of the aggravated stalking convictions for the defendant?
No, I wasn't.
Okay. That's all, Your Honor.
All right. Give me one moment. Okay. All right, defendant is going to receive a $3,000 surety bond, $1,000 on count 1, $500 on each remaining count. He's to have no contact with Ms. Booker. Again, contact can be revisited at the state all-purpose calendar, but for now, that's what it will be, and stay away from that location. Additionally, he's to have no alcohol, no drugs, no weapons, and again, the reset date will be the 21st. Is there anything additional?
Nothing further, Your Honor.
All right. Best of luck to you, sir. That concludes the case for now. Who do we have next?
Number 17, McCray.
All right, Mr. McCray, your case is 25 CR 004588D. You're charged with criminal trespass and obstruction. Do you understand your rights? All right, Mr. Howard.
19. I got a on probation for theft by receiving. It's 24 CR 007852Y. On probation out of DeKalb for ag assault. 2025 probation, 2024 failure to appear. 2021 failure to appear. 2021 violation of family violence order conviction.
All right, thank you, Ms. Fall.
Yes, Your Honor. This incident happened at the location of, let's see, 85 6th Street Northeast, which is the Biltmore at Midtown. Maintenance staff Patrick Harrison was clearing the property, and when he saw the defendant rummaging through a secured and fenced-in area used by the maintenance staff. As the officer went back to his vehicle, the defendant began to flee. The officer told him to stop. He continued to walk away. The officer then placed him under arrest. And at that point, the courtesy officer signed off. The courtesy officer was the person who placed him under arrest, turned him over to APD. We would ask for a $1,000 surety bond on this case, $500 on each count. The defendant has 2 FTAs in the last 5 years, in 2021 and 2025, and is currently on probation. So we are concerned he is a risk of reoffense as well as a risk to not return to court. That's all for the state. And we would ask him to stay away from the Biltmore at Midtown, which is located at 85 6th Street Northeast in Atlanta.
All right, thank you. Is this yours, Ms. McLeod?
It is, Your Honor.
All right, please proceed.
My client tells me that he does not have the resources to pay for a bond, Your Honor. So I wanted to bring that to the court's attention. This is a nonviolent offense. I would have asked for signature bond, but I realized that that he had an FTA in 2025, so he's disqualified. So I don't know if the court would consider maybe a small cash bond. He might be able to convince someone to pay that.
All right. Defendant's going to receive a $20 cash bond, $10 on each count. He's to stay away from the Biltmore, have no alcohol, drugs, or weapons. And I am going to ask for a social worker to come and visit him. Is there anything additional? All right.
Nothing from the state.
All right. Best of luck to you, sir. Who do we have next?
Question number 21.
All right. Sir, your case is 25 CR 004591Y. You're charged with cruelty to children and 1 count of battery family violence, 1 count of simple battery family violence. You understand your rights today? All right, Mr. Howard.
3rd, 06 probation, 06 obstruction.
Okay.
This Olive Font, right?
Yes.
Okay.
All right, thank you. Ms. Fall?
Yes, Your Honor. If you'll just give me a moment. Okay, this incident happened on August 8th, 2025 at the Whitney Apartments at 5555 F11 in Roswell Road. On Roswell Road, Jalea Lawton told police that she had had a verbal dispute with the defendant, which spilled over into the morning due to him confronting her over cheating allegations. And dispute became physical when the Mr. Oliphant showed video of the dispute, portions of the dispute. The defendant, according to Mrs. Zavala Lawton, struck her in the face when she attempted to take her phone back from him. She also stated that he pushed her around the house, tackled her to the ground while forcefully taking her phone from her. She tried several times to get her phone back, but he was pushing her with his hands and knees and not allowing her to do so. At that point, she stated that the defendant gathered all the electronics before stating he was leaving from work. And she told him she was calling the police at that time and tried knocking on neighbors' doors so that she could do so. The officers did observe a fresh laceration to her lip, and she also showed the officer the blood-stained towel that she used to treat the laceration. Both parties did advise that their 2-year-old daughter was in the home during the incident and could also be seen on some of the videos. We are asking for due to the nature of this incident and the fact that he did take away her phone, trying to leave her unable to contact the police, we are asking for a $3,000 surety bond, $1,000 per count, stay away from Miss Jala Lawton and no further contact with her, and stay away from 5555 Roswell Road in Sandy Springs. We are agreeable to a third-party contact with the child. We had an opportunity to speak with No, we have not had an opportunity to speak with Miss Lawton, but we would like to sound for her at this time. That's all for the state.
All right, is Ms. Lawton present and wishes to make a statement? Okay, hearing none, Ms. Rosenhofer?
Thank you, Judge. Mr. Oliphant is 39 years old. He has resided in Georgia for the past 10 years. He also has other family members that reside here in Georgia. He earned his associate's degree in hotel management, and he's currently a sales manager for a hotel. Additionally, Judge, he is a veteran. He served in our Navy between 2004 and 2007. And hearing from pretrial, I don't believe he has had any run-ins with the law in over 20 years. Judge, he has also advised me that while that incident location is his home address, it's his apartment. It's his understanding that the alleged victim is planning to move out and is going to go back to her family. I believe she's from Las Vegas. Of course, the state can confirm that, but Judge, we would just ask for a reasonable bond, given his lack of recent criminal history and his ties to the community. And we'd ask the court to consider allowing him to stay at that home as long as she is gone from it. Thank you.
Defendant is going to receive a $3,000 signature bond at level 2 through pretrial services, $1,000 on each count. He's to have no contact with the alleged victim. He's to stay away from that location if she resides there, but if she has moved out, he can return. He can return with law enforcement to make that determination. Additionally, he can coordinate the transfer of the child through a third party. He's going to take a 1-day anger awareness course, and he's to have no alcohol, no drugs, no weapons. His case will be reset. Further notice. Is there anything additional?
Did you say 1-day anger awareness, Your Honor?
I did.
Okay, thank you. That's all.
All right. Best of luck to you, sir. That concludes your case.
Position number 22.
I'm sorry, did you say 2 or 22?
22.
Thank you.
All right. Your case is 25 CR 004592H. In this case, you're charged with simple battery family violence. Do you understand your rights today?
Yes, ma'am.
All right. Ms. Falk, we'll go to you because this is our first arrest.
Yes, Your Honor. In this case, the defendant and Miss Kavita Baja, they are married. They've been married for 18 years. They were in a verbal altercation. Miss Baja was attempting to walk to the leasing office, and the defendant grabbed her arm, which is the subject of this incident. We did have a chance to speak to Miss Baja. She stated that they have been together for 18 years, and the last 2 years, the defendant has beaten her up and even kicked her out of the house. Ms. Baja stated she does not want the defendant back in her home and she wants absolutely no contact with him. For that reason, the state, although we are agreeable because this is his first offense, we are asking for a surety bond on this. I do understand it's his first offense, but given the circumstances and given her allegations that this has been ongoing for 2 years, we do have some concerns. So we are going to ask for a $1,500 surety bond. We're also going to ask for no further contact with Ms. Baja. We are further going to ask for no alcohol, drugs, or weapons, specifically no firearms. and a stay away from the address, which is going to be 6115 Abbott's Bridge Road in Johns Creek. That's the Aylesbury Farm apartment complex. We would like to sound for Ms. Baja at this time, and that's all for the state.
Is Ms. Baja present and wishes to make a brief statement? Okay, Ms. Rosenhofer?
Thank you, Judge. My client is 43 years old. He has resided here in Georgia for the past 6 years. He earned his bachelor's in engineering and currently does IT work. It's also my understanding that the incident location is his only place to go. He advised that he understands if the court issues a stay away order, he will have to figure that out. However, Judge, we would ask for a one-time police escort for him to be able to retrieve his belongings if the court does issue that stay away. And Judge, since this is his first arrest, we would request a pretrial signature bond. Thank you.
All right, defendant is going to receive a $3,000 signature bond through pretrial services at level 1. He's to have no contact with Ms. Baja at this time and stay away from that location. He can return one time with a member of law enforcement to get any items. He's to take the 1-day anger awareness course, and he's to have no alcohol, no drugs, no weapons. Is there anything additional? All right. Best of luck to you, sir. That concludes your case. What do we have next?
Judge, it looks like he might have a question. I would
Sir, what is your question? We advise you to invoke your right to remain silent, but what is your question?
Ma'am, I do not have any other place to live, and my kids stay at the same place. Was the first attempt or reason, and there have been no issues for the last year and a half. So I really request you give us a chance to reconcile, and we can come back in retrial if needed.
All right. I will consider that, but for now it will remain as I have ordered, all right? Best of luck to you, sir. Who do we have next?
Now don't change it. Go ahead and move.
Next.
Number 25, Tolliver.
Mr. Tolliver, your case is 25 CR 004595J. In this case, you're charged with hit and run and following too closely. You understand your rights?
Yeah.
All right, Mr. Howard.
Second arrest, 2016 DUI conviction. That's it.
All right, thank you, Ms. Falk.
Yes, Your Honor. This incident happened on July 15th of 2025, and the victim in this case is Miss Jasmine Beasley. Miss Beasley called the police and let them know that on that date, she was stopped at the intersection of Fairburn Road Southwest and Boulder Park Southwest, and the defendant driving a Range Rover failed to stop and collided with the back of her. She exited the car, approached the Range Rover, spoke to the defendant. They agreed to relocate to Boulder Park until the police arrived. But once she got into her car, the defendant pulled off and headed north on Fairburn Avenue, leaving her there and not failing to give the information belonging to him. The officers were able to run the tags, and it came back to the defendant. The victim was showed a picture of the defendant, and she did confirm that that was the person who hit her and left the scene. We did have an opportunity to speak with Miss Beasley. She stated that she was injured as a result of this accident. Her neck and upper back were injured. Her car was not a total loss, so she is still getting estimates on that. And she stated that when the accident happened, the defendant did come and talk to her to make sure she was okay, but then subsequently left without exchanging information. We are agreeable to a signature bond through pretrial services to have no further contact with Miss Jasmine Beasley, no alcohol, drugs, or weapons. And we are going to ask that the defendant not drive, given that he has a prior DUI and now a hit and run, that the defendant not drive unless to work, school, medical, or legal appointments. That's all for the state.
All right, thank you. Ms. Rosenhoover?
Thank you, Judge. Mr. Tolliver is 41 years old. The address on file in Lithonia is still a good address for him. He's resided in Georgia for the past 13 years. Several of his family members also live here. He's earned 2 master's degrees and has been a teacher in Georgia, in Georgia since 2011. He's currently working at the superintendent's office, training other teachers. Judge, and while Mr. Tolliver understands that today is not an evidentiary hearing, he has advised me that at the time of this incident, he will be able to prove later on that he was not the individual driving his own car and that he was out of state at the time of the incident. While again, this is not the hearing to address that. I did just want to let the court know that Mr. Tolliver intends to fight the case, and we would ask for a signature bond through the jail. Thank you.
All right.
And Your Honor, I did forget to sound for Miss Jasmine Beasley.
All right. Is Ms. Beasley present? Wishes to make a very brief statement? Okay. Defendant is going to receive a $2,000 signature bond through pretrial services at level 1, $1,000 on each count. He's not to drive unless he is going to work, medical appointments, legal appointments, or official business. He's to have no alcohol, drugs, or weapons. Is there anything additional? All right. Best of luck to you, sir. That concludes your case. What do we have next?
Number 27, Wilson.
Mr. Wilson, your case is 25 CR 004596E, and you are charged with criminal trespass. You understand your rights?
Yes, ma'am.
All right, Mr. Howard.
7/2022 disorderly conduct, 2020 probation, 2018 sale of marijuana, possession of a Schedule 1 or 2 first offender. He's homeless.
Okay. Ms. Falk.
Yes, Your Honor. This incident happened on, let's see, August 8th of 2025. The defendant was inside the Walmart at 5200 Windward Parkway. He was detained by loss prevention, and he was previously issued a criminal trespass on March 25th of 2025, indicating that he was not to return to that location. I didn't hear any FTAs or any current probation. The state is agreeable to a signature bond through pretrial services. Stay away from Walmart at 5200 Windward Parkway in Milton, Georgia. No alcohol, drugs, or weapons. That's all for the state.
All right, Ms. Rosenhoover.
Yes, Judge, we would not object to a reduction to a pretrial bond. He is unable to make that $1,000.
Okay. All right, defendant's going to receive a $5 cash bond. He's to stay away from that location on Wentworth Parkway, have no alcohol, no drugs, no weapons. Is there anything additional? All right.
$5 cash bond, Your Honor?
Yes, correct.
Your Honor.
All right. Best of luck to you, sir. That concludes your case.
Wait,
Who do we have next?
or $5?
$5.
Okay.
$5. I did it like you could see me write a 5. My apologies, Ms. Strong.
Judge,
All right.
Mr. Wilson appears to have a question.
Mr. Wilson, your question, very briefly. Don't say anything that will incriminate yourself. You have an attorney here to assist you.
I have nobody that can help me, and I was trying to see if I can do the signature bond because I'm literally by myself. Like, there's nobody that can help me right now at this moment.
All right. For now, it will remain as said. I will consider your request. All right. Best of luck to you, Mr. Wilson. Who do we have next?
We have Mr. Kilgore Hernandez, but he's not on the calendar.
He's on the add-on.
He is on the add-on.
Okay, Mr. Kilgore, your case is 25 CR 004587G. You're charged with theft by taking. You understand your rights? Okay, I'm gonna assume that's a yes, Mr. Howard.
31. You got to open shoplifting from June 1st. One from March 19th. Well, he was arrested anyway. 2021 FTA, 2 of them. 2019 shoplifting conviction, 2019 failure to appear.
All right, thank you. Ms. Falk?
Yes, Your Honor. This happened August 4th, 2025 at 5021 Old National Highway in College Park. The officers broke up a fight at that location. Well, what was about to be a fight, or what was a fight. According to Mr. Liddell Williams, the defendant stole his items, including some clippers that he had. The defendant's bag was searched, and because the defendant did give consent for search of his bag, and officers did observe the silver hair clippers that were belonged to Mr. Williams in the defendant's bag. The defendant also took Mr. Williams' cell phone. The defendant claimed that he took the cell phone to prevent it from being stolen by others and took it downstairs and gave it to another male subject. We do ask for on this case, a $1,000 surety bond that is based on the defendant's history of FTAs. I believe I heard 2 in the last 6 years, as well as open theft cases. This is yet another theft. We are also asking that he stay away from 5022 Old National Highway, 5021 Old National Highway in College Park, which is the Best America Inn. We're further asking that he have no further contact with Mr. Liddell Williams, no alcohol, drugs, or weapons. That's all for the state. We would like to sound for Mr. Liddell Williams if he is here.
All right, is Mr. Williams present? Ms. McLeod?
Yes, Your Honor. My client is 58 years old. He is a native of Atlanta, Your Honor, and tells me that he lives in Fairburn. He also tells me that he's currently unemployed and has no one to bond him out. So I'm asking the court, given that this is a nonviolent offense, and he also denies that that is what happened, Your Honor. He said he did not. He thinks that somebody else may have been trying to set him up by putting the alleged victim's stuff in his bag. He said he did not take it, and he had given the police officers permission to look in his bag because he did not expect that there would be anything in there because he did not actually put anyone else's stuff in his bag, Your Honor. So I'm asking the court to consider that because he has no one to bond him out. Nothing further.
Defendant's going to receive $1,000 surety bond. He's to stay away from that location, have no contact with the alleged victim in this case, Mr. Williams, and have no alcohol, drugs, or weapons. He's going to be reset to all purpose on the 21st. Is there anything additional?
Not from the state.
Nothing further from the defense, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
Number 12, Hilborn.
I think my client is trying to say something, Your Honor.
I'm sure everyone has a question today. Very quickly, what is your question?
I'm just saying that my wife's disabled, and I'm really the one who takes care of my wife, and I was trying to see could I have a signature bond for today.
All right, bond will remain as set. Who do we have next? Best of luck to you, sir.
Number 12, Hilborn.
All right, Mr. Hilbert, your case is 25 CR 004584F. In this case, you're charged with criminal trespass. Do you understand your rights?
Yes, yes, ma'am.
All right, Mr. Howard.
Two. Got an open theft by taking in the cab. Disorderly conduct, obstruction, trespass, and Clayton. 2019 burglary, conditional discharge. 2018 shoplifting NOLO, battery conviction, theft by taking conviction. 2016 2 trespass convictions in these homes.
All right, thank you. Ms. Falk?
Yes, Your Honor. This happened on August 8th, 2025 at 405 Cooper Street Southwest. The defendant was at that location. A loitering prowling call had been called out at the Buckhaven construction site zone at that location. The defendant was trying to pull up the iron stakes and tampering with the silt fence. That was all captured on drone video, and it took place during construction hours with construction equipment around, so there was concern for his safety. The state would ask for a $500 surety bond, stay away from 405 Cooper Street Southwest in Atlanta. We are also asking for a social worker visit on this case. The defendant does have some history, which is why the state is asking for a surety bond. That's all for the state.
Thank you, Mr. Getty.
Yes, thank you, Your Honor. My client is 30 years old and has told me he's a lifelong resident of Georgia. He has multiple family members living in Georgia, but they are a bit spread out. He has expressed to me that he's a high school graduate. He has some inconsistent work that he's been able to maintain, but most importantly, he has expressed to me that he has already been in communication with such groups as Safe Outreach, Gateway, and Hope Atlanta, who are in the process of trying to help him find long-term stable housing. So I would just ask that he be given, if he's eligible for UJR, I would ask the court to consider that. But if not, the lowest possible bond, just so that he can continue to work with those organizations to get himself into more stable circumstances.
All right, defendant's going to receive a $5 cash bond. He's to have He's to stay away from that location, have no alcohol, drugs, or weapons. Is there anything additional?
No, Your Honor.
All
No,
right.
Your Honor.
Best of luck to you, sir. That concludes your case for today. Who do we have next?
We got Mr. Pet. I don't want to mess this man's name up.
Take your
But
time.
he's not on the calendar, but he was on our pull sheet. Mr. Say your name, sir.
And the top material.
Oh, okay.
I'm
Wasn't he
back
on the
here.
pool sheet yesterday?
I'm sorry, I'm not sure what is your name again, sir?
It's PETATAN
Yes.
hyphen Quiterio.
Yes, that was actually given a PI number. So that is that should have gone to the felony court yesterday. It was accepted under 25 PI 006403. So I'm not sure what occurred, but we were given a PI number and it was scheduled to go to felony first appearance yesterday.
And Judge, just for context, I had the opportunity to speak with him. I was equally as confused. It does look like it's a different warrant. I don't know if the felony attorneys caught it or if it came in after.
It came in after.
Okay, so I think it's a separate charge that's holding him in.
Okay. So I was not aware that they had actually taken out two different warrants on him because, Your Honor, this came in after the first warrant, which was sent to the DA's office because he's a recidivist. So we would ask that the second warrant be treated the same, but we're still going to need to give him some, I don't believe he has any bond on this. Wait, yes, he does. He has $1,000 surety bond. So, Your Honor, on this case, we would ask that we just keep the bond remain as set, advise the defendant of his charge, and the state will ask on Monday for this case to be joined with his other case, which is currently in felony court because of his recidivist status.
So this case doesn't have a CR number.
It does not have a CR number. It does not have a PI number because it was added after the first case was sent to the DA's office and given a PI number.
So yeah, then if it's no CR number, nothing we can do today, Ms. Rosenhoover. So, sir, you'd have an additional charge. Apparently there's $1,000 bond on it, and you'll have another hearing about these charges at a later date, okay?
Okay. And Your Honor, just to advise the court, he will be going to court on Monday. So we'll make sure it goes to felony first appearance on Monday.
All right. All right, sir. You'll be in court on Monday.
Yeah, you got $1,000 already preset. That's what she's saying.
So I could pay that and get out.
Yeah.
Okay, so what about I know we have a waiver. What about position 4?
Position 4.
3 and 4.
They were he's a reset. He was a medical reset on yesterday as well.
Okay.
So it's a medical reset again?
Yes, ma'am.
Thank you.
For 3 and 4?
It's the same person.
Oh, I'm sorry. Sorry.
No worries. It's that kind of day, Ms. Strong.
What about position 10?
Position 10 is a reset. I went back there to get him before court started, and he got some MH going on. He wouldn't even comprehend with me. So,
Okay. All right. Position 20.
Yeah, well, Your Honor, before we move on from position 10, can I ask Ms. Rosenhoover or one of the attorneys today to make sure that a social worker goes out there to see him before Monday so that we don't end up resetting?
I was gonna make that same announcement at the end, but hold on, because it may be that this applies to more than one person.
Yeah.
So what's the announcement for more?
I gotta go get her. She's in medical. She's in a wheelchair, so I gotta go get her.
Okay.
So
she's not gonna be a medical reset. Okay. So all the medical resets, if the public defender's office will do their best to please try to make some contact so that we don't have to keep resetting. So I think that's gonna apply to 3, 4, and 10, perhaps,
Yes.
and the others that were medical recess that we discussed earlier, perhaps. Oh, 14 bonded out.
At 14 bonded out, well, he was gonna be a medical reset. When I went back there to get him, he was seeing the doctor at the time. And then I guess his bond was posted in the process.
Okay, that's fine. All right, and I'm sorry, what was our waive position?
Number 23, Simmons.
I'm prepared to move forward on that, Judge, whenever you are.
All right, let's take up the waive case of Derek Simmons, 25 CR 004593A, in which he's charged with obstruction. Mr. Howard, the history?
Who is this?
23 Simmons.
Oh, he got over 40. On probation out of Muskogee. Possession of meth. 2025 trespass. 2025 burglary. Use of a firearm by a convicted felon. That was dismissed. 2 probations from last year. 3 trespass from last year. One of them was a conviction. 2023 obstruction conviction. 2023 8 counts of terroristic threats. He's on this.
Okay. Thank you, Ms. Falk.
Yes, Your Honor. Officers were patrolling the area of 2790 Lakewood Avenue Southwest on August 7th of 2025. They observed they had a bolo for the defendant for a burglary in the area of Metropolitan Parkway and Aaron Avenue. They did observe the defendant. The defendant observed them and began walking away across Metropolitan Parkway. They began giving verbal commands, telling him to stop. He then started running. There was a foot chase, and he was found lying in a prone position near a trash can on the side of a building, where he was then arrested and taken into custody and charged with obstruction. Given that he was a suspect in a burglary case, I believe is another warrant forthcoming. However, there has not been one taken out one put into the system at this time. But given his history, we are going to ask for a $1,000 surety bond. We are going to further ask for no alcohol, drugs, or weapons, and that's all for the state.
All right. Ms. Rosenhofer?
Thank you, Judge. Mr. Simmons is 42 years old, and while he is listed as residentially challenged, he provided me with the address of a rooming house where he would be able to receive notice of his next court date. I can provide that at the end of the calendar. He's resided here in Atlanta since January. He has a son in Columbus, Georgia. He made it to the 11th grade, is currently unemployed. And Judge, he did disclose that he does have mental health and substance abuse issues and is currently, or has at least somewhat recently, received outpatient treatment and medication. I don't know specifically what his plan in place is, but he was very clear that he is not able to afford any kind of bond and doesn't have anyone that can help post it.
What was the current bond? I'm sorry, Ms. Falk.
There was no bond, actually.
Oh, there was not.
The
Okay.
state is asking a $1,000.
Okay, I was wondering if that was a preset. Okay. Let me look at one thing. All right, defendant is going to receive $1,000 surety bond. He's to have no alcohol, drugs, or weapons, and will be reset to all purpose on the 21st. All right. Have we done every case that we can do with the exception of the young lady that needs to be brought from medical? I believe so.
By your order, I'm going to get her now.
All right, Ms. Strong, while we're waiting, can we go ahead and review the calendar that we have done?
Position number 1 is a $1,000 good bond reset for August the 21st. Position number 2 was a $2,000 good bond. Position number 3 and 4 are reset for Monday's 2 o'clock calendar. Position number 5 is a $3,000 signature bond through pretrial level 1. 6 is a $5,000 signature bond through the jail. 7 is a $1,500 good bond. 8 is a $1,000 good bond. 9 is a $20 cash bond. 10 is reset for Monday. 11 is a $3,000 signature bond through pretrial level 2. 12 is a $5 cash bond. 13 is a $50 cash bond. Position number 14 was released. 15 is a $5,000 signature bond through the jail. 16 is a $3,000 good bond. 17 is a $20 cash bond. 18 is reset for Monday. 19 is a $3,000 good bond. 20 we're holding on. 21 is a $3,000 signature bond through pretrial level 2. 22 is a $3,000 signature bond through pretrial level 1. 23 is a $1,000 good bond. 24 is a $3,000 signature bond through pretrial level 1. 25 is a $2,000 signature bond through pretrial level 1. 26 is a $1,000 good bond. 27 is a $5 cash bond, and the add-on, Mr. Kilgore, is a $1,000 good bond.
Really quick on position 7, I had okay, that's a $1,500 surety bond.
Correct. 1,000 on the first charge, 500 on the
500
second.
on the second, and then on number 2, I had a $3,000 surety bond.
Was it 3?
I don't. That's why I'm asking. I wasn't sure. Maybe I wrote
Number
it down
2, I got 2,000.
I have 2,000.
Okay, great. 2,000 it is. All right.
And
Thank you.
Mr. Smith, you still here with us? We weren't able to get any assistance.
Oh, I wasn't able to assist him. But I didn't have the information he needed. So
Okay, so since we have a natural break, if someone could assist Mr. Smith, I would
Wait, I'm sorry.
appreciate it.
Mr. Smith is which
The
one?
attorney for Tamiko Cameron. Is it Tamiko Cameron?
Tamiko Cameron. Yeah, I sent him the NOD as he requested to his email address. It bounced. I got a return notice saying he's on leave for his anniversary. So, but I did email him the NOD as he requested. So I'm not sure why he's still
Smith,
on the line.
Mrs. Smith, you still here? I will hope you're not having to do this on your anniversary.
Probably gone.
Okay.
I think he might be gone. He just didn't disconnect.
I hope so. Okay. All right. Well, we'll just be on a brief hold until we have the other young lady. Thank you all.
Thank you.
This is Miss Calloway, the advocate. What was number 26?
I don't remember.
26 was a $1,000 total surety bond.
Okay.
And Miss Calloway, if you have any other questions, feel free to text me in the chat.
All right. Thank you. I will do.
No, Mrs. Smith is gone. Thank you all.
Thank you, Mrs. Smith. Take care.
Shelley, you got the history for more?
I do. You need me to give the history when it comes up? Okay, yes. I can do that. Pre-trial, can you do me a favor?
Position number 20, Ms. Moore is available.
Yep.
I was going to ask if you could find out what Ms. Moore's bond was at felony first appearance.
1,000, 1,000, 1,000. It's 5,000 total. 1,000.
Okay. Thank you, Ms. Moore.
All right, Ms. Moore, your case is 25 CR 004603G. You're charged with giving false information, driving with a suspended license, speeding, unsafe vehicle or equipment, and having a windshield wiper violation. You have a right to remain silent. You have a right to an attorney today. And as you can see, I am conducting this hearing by video. I'm not in person there with you. It's being recorded and broadcast as a live stream. Do you understand your rights and how I'm conducting the hearing today?
Yes, ma'am, I do.
All right, thank you. Ms. Falk, will you give us this history?
Yes, Your Honor, I can. So her history is, let's see, she has, sorry, I'm going through. Okay. Let me go to, we had two cases on her, and at one I have the driving history, so I need to go to the other one. All right. Okay, back on track. So we are looking at a total of 41 cycles. The most recent arrest was this one. Previous to that, she had a failure to appear May 1st of 2025 out of Cobb County, a failure to appear November 17th, 2021 out of Cobb County, endangering a child by driving under the influence of drugs or alcohol, and a DUI that was December 2021 in Baldwin Municipal Court, a arrest in Cobb County for hit and run, DUI, and willful obstruction. I don't see a disposition on that. That was on October 28th of 2019. I'm also seeing a 2017 possession of firearm during commission of a felony, possession of a knife or firearm during commission of a felony. She was sentenced on that case to 5 years suspended on February 18th of 2020. That's a Fulton County case, and that case number is 17 SC 154621. Would Your Honor like me to continue? That's
No,
what she
I
has.
think that's relevant. That's good.
Okay. Additionally, she, as you've heard, is currently has a bond for 3 cases that she has currently in felony court. Those cases are aggravated assault, giving false information to a law enforcement officer, identity theft or fraud, and fugitive from justice. On this case, Your Honor, she was, let's see, let me go back to her actual report. On this case, it appears that she was on August 7th of 2025. She was driving 45 in a 30-mile-per-hour zone. That she was clocked at 49 miles per hour in a 30-mile-per-hour zone on North Commerce Drive. She was pulled over. The officer observed a spider web crack on the front windshield, as well as a crack to her mirror, her I guess, side mirror. The officer asked her for her name. She provided the name of Whitney Presley with a date of birth of 5586. The officers, it came back to another individual. She then admitted that her real name was Zarakara Moore, and gave the correct date of birth. Upon running that, it showed she had a failure to appear for a suspension in 2021. She was then placed under arrest and charged accordingly. I will say the name that she gave, Whitney Presley, was the same name of the victim in the identity fraud case that she is currently charged with in the DA's office. So she is using that name not only in the felony case, but also was using it in the misdemeanor case. Given her history that includes apparently fugitive from justice, as well as aggravated assault charges, identity theft charges, as well as previous history involving possession of a firearm, and I believe when I was going through the history, FTAs, we are going to ask for a $5,000 surety bond, $1,000 per count. We are also going to ask that she have no further contact whatsoever with Whitney Presley, and no alcohol, drugs, or weapons. And no driving whatsoever. That's all for the state.
Okay. All right. Ms. Rosenhofer?
Thank you, Judge. Miss Moore is 47 years old. She is a lifelong Georgia resident. The address on file is for a home that she owns. She does have 3 of her children residing with her in that home, but she has 7 children in total. She graduated from Carver High School, attended some college, and she has been running and operating her own company here in Atlanta for the past 5 years. We would just request reasonable bonds on these misdemeanor offenses. Thank you.
All right. Give me one moment. Okay. Defendant is going to receive a split bond as follows. On the giving false info. Sorry. Close that door. Okay, apologies for that. Defendant is going to receive a split bond. It'll be a $500 signature bond through the jail on count 1, a $500 surety bond on count 2, $1,000. I'm sorry, I did that wrong. Let me start again. It's going to be a $500 surety bond on count 1, $500 surety bond on count 2, $1,000 signature bond through the jail on count 3, $1,000 signature bond through the jail on count 4, and $1,000 signature bond through the jail and for count 5. So that should be a $4,000 split bond with her having to make bond on $1,000. And she's not to drive unless she's going to work, to a medical appointment, to a legal appointment, or other official business.
Your Honor, being that she has a suspended license.
Or unless she has a valid license.
Yeah.
If the license is valid, but even once she gets once she clears the suspension, those provisions will still attach.
Thank you.
Does that make sense, Ms. Falk?
Yes.
All right.
So you can start through the jail on all the other 3 charges?
The 3 remaining charges are through the jail.
Okay, thank you.
All right. Have we completed the entire SCA calendar?
Yes.
Any other outstanding issues?
No, other than can we have the no further contact with Whitney Presley on this last case?
Yes, we can. But typically, Ms. Falk, when it's an identity theft, they're not contacting the person; they're just using their stuff.
But because I don't know the nature of this one, there are identity frauds where it's somebody the person knew, like a family member or a friend. Because I'm not sure what that relationship is, I wanted to ask out of an abundance of caution.
Okay, so no contact with Ms. Presley.
Thank
and
you.
no use of her information either. All right. Best of luck to you, Miss Moore. Take care. Have a good afternoon. I believe we will be in recess until is there SCA on Monday? I'm so
Yes.
Monday's SCA calendar. Take care, everyone. We didn't do too bad for how large this calendar was. So have a good afternoon. Try to enjoy the rest of your Saturday. Miss Strong, I'll sit here until I get the orders so that we can get them in a timely manner.
Thank you.
All right. Take care, everyone. Bye-bye.
Have a great weekend, everyone. Bye.